Ready? Let's get settled in to hear from Laura Quatela. Okay, so thank you all for coming to this keynote. We are so excited to have Laura here today and very grateful. She has been the Senior Vice President and Chief Legal Officer at Lenovo for 6 years. In that role, she was named Top 20 General Counsel by Financial Times. She was previously the Executive Vice President for Intellectual Property at Alcatel-Lucent, and she was President of Eastman Kodak, where I just heard that she was responsible for making $4 billion of revenue out of their intellectual property portfolio. And she has her JD from Case Western here in Cleveland. I also hear from those who've worked with her that she's an excellent business strategist, and that she also works hard to champion junior lawyers and junior professionals. So without further ado, here is Laura. Thank you again. Thank you, Krista.
Oh, I have to get, okay. Forgive me if I rub my hands together a lot while I'm speaking. It's freezing in here. Let me start by thanking Dean Fisher and Krista and the rest of the organizers of the IP Plus conference for inviting me to Cleveland. I did attend the competitor law school, so it's kind of you to let me in. It's my privilege to join this IP savvy, or at least IP interested audience. And I want to thank especially my former colleague and friend, Carl Mersch, for thinking of me in relation to this event. And Chris has taught me easy prompter, so I'm also struggling a little bit with newness of that, so be patient with me. I understand that I follow here in the very big footsteps of my law school classmate, Judge O'Malley, who gave a keynote address last year or the year before. Kate and I spoke on a panel at intellectual, what does that stand for, Carl? IPBC. I never think of what it actually means. IP Business Conference, a few months ago. And I described her as the person who was always sitting in the front row and who always had the answers before I, sitting in the back row, could even make sense of the questions. And that's why she so deservedly made her way to the bench. And I have to warn you that I'm a little bit of fake news. I came to IP mid-career with no technical background whatsoever. I still have no technical background whatsoever. I did have litigation chops, but I was an in-house business lawyer at Kodak by the time our general counsel pulled me aside to share that the head of the IP group would be retiring in a year and that I was in line to succeed him. I remember saying, I don't even know where the research labs are. I guess I was a bit ungrateful, but I was very nervous about trying to establish myself in a very heady world that I didn't have any background in. But the general counsel had a plan. I would apprentice under the very wise IP leader for his remaining time at the company, and then they'd take stock of my prospects. For any of you who are law students, I don't know if there are any law students in the room, but this is how career development can happen. So at another time, perhaps we can talk about risk-taking in the professional sphere. I want to return to the Kodak days in a moment, but first let me give you the familiar disclaimer. The views, particularly given that my company is a Chinese heritage company, the views I'm representing here today are mine and don't necessarily reflect the opinions or the positions of Lenovo Group. So that's my housekeeping. With your indulgence, I'd like to compare and contrast a little bit today my IP experiences at Kodak with my IP observations from a very different chair at Lenovo. I did come to head the IP group at Kodak as chief IP officer, and there were business roles afterwards. As Krista mentioned, I was president of the company and then COO. But for reasons I'll walk you through, by the time of my advancement, intellectual property was Kodak's lifeline, or maybe some would say it's death knell, depending on how you look at it. And even the operating executives in the company then needed a working knowledge of IP just to keep up. Wherever I was in the company, in whatever role, I was surrounded by IP experts, really, really fine teammates, and we were steeped in patent generation and patent and brand licensing. At Lenovo, on the other hand, I only have a bird's eye view of IP at this point from the chief legal officer seat, We have a fabulous chief IP officer. We have a fabulous head of IP litigation, and they take the lead, and I sit back and watch. I'm responsible for ESG at Lenovo and for government relations and trade during what could not be a more controversial time for a China legacy global company. So I'm a little busy. The point is, I do have some luxury of distance from the practice, which enables me to notice some things that I didn't necessarily get from the trenches, some things that I deeply appreciate, some things that drive me nuts. On the latter list is FRAND, fair, reasonable, and non-discriminatory licensing terms, for those of you who don't follow it. In my view, it's a well-intended principle gone horribly wrong, but I'm going to come back to that in a little bit. First, let me zip through Kodak's digital camera IP story. For those of you who don't remember purpose-built cameras, they were standalone devices dedicated to digital image capture through a CCD sensor array. They had nothing at all to do with mobile communications or with TikTok. Steve Sasson, who Carl knows well, a young Kodak technologist, invented the digital camera very early on in his career in 1975. His manager was sure that Steve's idea was the company's next big thing, and he arranged for Steve to come downtown and showcase his invention to Kodak's senior management. Apparently the words "replace film" were used during that presentation, and Steve's camera prototype, which was about the size of this podium, ended up in a closet for 20 years, 20 long years. In the meantime, more than 30 other companies managed to commercialize digital cameras. I remember, I don't know, Carl, I don't think you were with us then. I remember so clearly the morning the first digital image appeared on the front page of the New York Times. It sent a shockwave through headquarters. The headquarters were, at that time, we realized, sinking, but anyway, that's another story. Film is dead. Film is dead. That's what everybody was chatting about that morning. But remember, Kodak hadn't entered the digital camera market for fear that the product would cannibalize film, the product responsible for 80% of the company's revenue at that point and 85% profit margins. So enter a young and energetic Willie Shih, who is now a professor at Harvard Business School. At that time, he was an extraordinarily visionary young executive who was recruited from Silicon Graphics in Silicon Valley to launch the digital revolution at Kodak. But he quickly assessed that the race had been run and won by all of those other companies in the digital camera business, and there was no catching up at this late juncture. But Willie also discerned that Kodak was sitting on a treasure trove of patents, more than 10,000 patents covering digital image capture and digital camera technology, all of which were being infringed by the incumbents. So Carl and I were lucky to figure very prominently in the rest of the story. My first task as the new uninformed head of the IP group was to launch a global digital imaging licensing campaign. Carl was a promising young litigator at Jones Day, the firm we hired to sue one of our early holdouts in licensing discussions, Sony. At that time, the litigation involved the highest number of patents ever asserted and counter-asserted in one lawsuit, almost 70. Eventually, Carl joined our in-house band, and we circled the globe collecting royalties and patent purchase payments, as Chris has said, to the tune of $4 billion over 5 years. This money enabled Kodak to meet its employee pension and other obligations and to stave off bankruptcy for half a decade, which is why I referred to IP earlier as either the lifeline or the death knell. When we reached our ultimate target, which was Apple, with the highest volume of digital cameras in their phones at the time, we learned a pretty hard lesson. Apple had a huge pile of cash, of course, even then, and it was able to deploy every litigation delay tactic available while watching us burn through our dwindling reserves. So for the lack of that new deal and no new upfront royalty payment that would have exceeded, in that case, $1 billion, Kodak had no choice but to file bankruptcy. The day after we filed, Apple, which had insisted to us for years that cameras don't sell phones and therefore lack IP value, Apple launched a multi-$100-million ad campaign that you probably remember shot on an iPhone with its powerful and provocative black and white images plastered in New York Times or in Times Square and other capitals around the world. That campaign promoted the upgraded 8-megapixel camera on the iPhone 6. So my last act at Kodak was to manage the iconic bankruptcy. We paired efforts with American Airlines, which went into bankruptcy the same day we did. You might know that when bankruptcies of that magnitude occur, the potential filers often consult to make sure that they go into different jurisdictions and don't overwhelm the bankruptcy system. So American filed in Texas, and we filed it in New York. So what I see about all that now from my current 30,000-foot perspective is much more about the how, the why and the how of what we did than it is about the end result. And this is where the contrast to what I'm seeing on the receiving end of patent assertions against Lenovo becomes interesting. So what are the key differences between the licensing approach in the early days, using Kodak as a proxy, versus current practice? I should say up front that some, but not all of the differences I observe are due to the fact that we were largely engaged at Kodak, of course, in offensive implementation patent licensing activity. And I'm generally on the defensive side of SEP, standard essential patent assertions today. But most of what I have to say goes to team dynamics and behaviors, which should probably be an apples-to-apples compare across. In earlier days, licensing teams tended to be cross-functional, with capable legal, business, and technology resources skilled in infringement analysis and claim charting, notice and assertion requirements, competitive intelligence, market dynamics and business performance, litigation, royalty accounting, and external communications. That was the team we built at Kodak to support our substantial licensing program. And we saw that same approach taken by especially operating companies and some of the more sophisticated non-practicing entities across the industry. It's just how we did it. Before program launch at Kodak, we spent a full 2 to 3 years analyzing, vetting, mapping, and valuing our own portfolio to prepare it for assertion and looking at potential target companies' portfolios to anticipate possible counter-assertions against Kodak products. At the same time, we dug into geographic market and industry sector dynamics to understand things like which targets had the highest volumes and profit pools of infringing products, in which countries potential targets would be more likely to take a license without litigation, what a particular company's litigation profile was like, and what its possible infringement defenses could be. We also prepared to tell Kodak's story of investment in basic research and advanced innovation through our inventors, including Steve, who I've mentioned, and product development leaders. In fact, in Steve's case, we paired him, he's a rather shy guy, very sweet and shy. We paired him with a CNN former anchor, consultant for media training, and we nominated him for every technical award on the planet, all of which he won, including the National Medal of Science, Technology, and Innovation, which was presented to him by President Obama. It was a great way to seal his credibility and reputation, anticipating that at some point he would be serving as a witness. So after delivering a substantial assertion package to a potential licensee, always directed to their head of IP, we would reach out a few weeks later to arrange a first meeting between our business teams. Carl was telling me a story last night where he has done this more recently for a client, and he did exactly what we did, which was to start the long process of relationship building with the people on the other side of the table who we'd be negotiating with. And they were surprised that he didn't want to talk shop at the first lunch, right? He just wanted to get to know their personal stories. I think you'll hear more from Kip about that a little later on. At the end of the day, we were usually looking for a 9-figure check. And you just don't show up and ask for that without having some basis of mutual respect and understanding. That kind of decision is typically made at the top. So the other thing we did was to take time to really understand who was the decision maker and what was the escalation process, et cetera, et cetera. So starting from that first call for a first meeting, we in the 18 or 24-month period, which was our average to come, our technical team worked really, really closely with their counterparts on claim construction and infringement positions. We threw the business team, so we would divide ourselves, business team and technical team. The business team just threw ourselves into relationship building. Some of my most meaningful and long-lasting friendships developed with people on the other side of the table, in Japan, Taiwan, South Korea, Scandinavia and North America, my kids will pick up the phone, to the extent they still do, at times, and hear a foreign accent and say, "Oh, Mom, it's one of your licensing friends." But they still call. So we have great friendships. Those relationships that we cultivated became vital when the teams, business or technical, reached impasse in the face of a sizable gap in positions. Sometimes those gaps were to the tune of hundreds of millions of dollars. By this point, each counterpart would understand the other's objectives, what I need, what you need. And through the foundation of trust established over many face-to-face breakfasts, lunches, dinners, tours, hikes, après-ski drinks, curling matches, remember those, wine tastings, whale watching expeditions, temple visits, hospital visits, that's a whole other story, and notably the rainiest day ever experienced on Australia Day in Sydney Harbor. It enabled us to find the win-win that became frameworks for resolution. At this magical moment, and only then, never before, we would engage our CEO to close the deal. Some of the smaller ones we did ourselves, but the big ones he stepped in for. Typically, he was acquainted with his counterpart because they were industry competitors. We never had a settlement proposal rejected. There was respect for the difficult and exhaustive journey the teams had taken. There was ensuing business collaboration. There was decorum. Fast forward to Lenovo. First, let me just familiarize you with the company a little bit. We make these things, but that's not what we do. We were founded in Beijing in 1984 as a consumer electronics reseller, kind of a Chinese version of Best Buy. Our chairman and CEO today, Yan Yanqing, known to everyone as YY, for good reason, delivered computers to business customers on his bicycle. The early Lenovo had no need for patents. As the company grew domestically in China, YY was promoted to positions of increasing importance. He really yearned to take the company to the world outside. So in 2005, he led the acquisition of IBM's ThinkPad laptop computer business and entered international sales markets. 9 years later, in September 2014, Lenovo bought IBM's x86 server business, and the next month, imagine this for those of you who work in M&A, the company closed on the purchase of Motorola Mobility from Google. So it's a very, very busy time. Today, Lenovo ranks 171st on Fortune's global company list. We are number 1 in the worldwide PC market. 1 in 4 laptop owners globally works or plays on a Lenovo product. What does this mean from an IP perspective? I'm sure you can guess. We're a target. I understand that fully, and I was prepared for it. So now I'm on the other side of the table, right? What has surprised me, though, is that it's no longer, as Carl described it to me last night at dinner, it's no longer a gentleman's game. There's no decorum. Building mutual respect in order to achieve a win-win outcome is no longer a priority. But probably more important, I see little investment of time and effort on the part of IP owners, whether operating companies or assertion entities, to build a story around their investment and my infringement to demonstrate why my management should write that big check. It's now a drive-by game, totally. I don't think this portends well for the IP practice, or in the case of consumer electronics, for consumers themselves. I'm guesstimating that Lenovo, Motorola, and our various affiliates around the world receive 5 to 10 so-called notice letters per month. At any given time, we're managing 50 to 60 open assertions, not counting litigation matters. Total demands and pending lawsuits against us in the IP space exceed $2 billion. These days, assertions typically start with a letter directed, devoid of any useful detail, by the way, and directed to my boss, coupled with a demand that he lead Lenovo in negotiations. For any of you who represent patent owners, let me offer a tip. My boss is running an $80 billion company doing business in 186 markets. Your letter to him will automatically be redirected to me, the chief legal officer, and it's going to signal to me that your client really doesn't want to engage in meaningful conversations. Rather, you want to get to the end game and get the check without ever discovering if there's a win-win solution for us. It's not a good look. Let me ask you, not counting transactions completed during the pandemic when the real estate market has been crazy, How many of you here have bought a primary residence without inspecting it first? How many of you have purchased a home without knowing the comparables in the area? This brings me to Standards Essential Patent Licensing on FRAND terms. The Ninth Circuit 2012 ruling in Microsoft v. Motorola, litigation which entirely preceded Lenovo's acquisition of Motorola, so the strategy of the case cannot be ascribed to me, endorses the proposition that an agreement with a standard-setting organization to provide RAND or FRAND, whichever, but they're almost interchangeable these days. I use FRAND. To provide FRAND terms to licensees constitutes a contract, and the patent infringement injunction should be avoided in favor of negotiating a FRAND licensing agreement. I don't know if many of you are familiar with that case, but it was a bit earth-shattering. But the rest of the world clearly didn't listen to the ruling. Naively, I thought this decision and those that followed would lead to transparency and reason in SEP licensing. Patent owners would need to take the time to hold open houses, if you will, to showcase their patent's relevance to the standard. They would enable potential licensees to inspect the assets before buying the roof for over their head in the form of a license. To the extent licensors had already licensed others, they would provide rate cards or comparables to justify pricing. By the way, another tip. To business decision makers in operating companies considering royalty demands, the key question is, how much is the competition paying? Code 4, will our accused product bill of materials cost exceed our competitors if we take this license? If you or I can't answer this question in the negative, we're unlikely to remain in our in-house or out-house rules for very long. I couldn't have been more wrong about what Microsoft v. Motorola portended. I did expect it would take us back to more refined times, to the kind of dignified approach to licensing that Kodak and others had developed. Instead of transparency, however, we have obfuscation. Lenovo is currently battling in the UK, Germany, the US, and China, so one multi-jurisdictional case. One of the biggest obfuscators of them all, which I won't name, but you can find, which has constructed a spider web of bespoke, convoluted agreements with others which we believe the specific aim of this construct is to hide comparables from targets like us, so as to make it nearly impossible to answer that question that is critical. Will we be paying more for this technology than our competitors? Our strategy of the case is to shine the light of day on the NPE's actual deal pricing so that buyers like Lenovo can make informed purchase decisions. In other words, to force transparency into the system. And remember the Ninth Circuit's guidance that patent infringement injunctions should be avoided in favor of negotiating FRAND terms? Well, I don't have to point the way for you to the race in Germany, the UK, and select other jurisdictions to enjoin potential licensees from selling products without paying before they can know if the pricing on offer is fair and reasonable. This is not taking us back to civility and win-win outcomes. Indeed, it has spawned the entirely illogical and hugely expensive multi-jurisdictional practice of anti-suit injunctions and anti-anti-suit injunctions and anti-anti-anti-suit injunctions, and so forth. Can these trend lines possibly play out in a manner that bolsters innovation? Or will it serve ultimately to stymie the implementation of new technologies or to raise prices for consumers looking to adopt them? Let's keep an eye on one of the latest patent battlegrounds around video codec, or HVEC standards. In 5 or 10 years, will your smartphone or my laptop deliver H.265 and later standards capability for our enjoyment in watching our videos and consuming other content? Or will we have to pay extra for that option? Will it even be available? All right, I've ranted. I'm ranting. Let me shift gears before I get myself into much more trouble. I'm going to talk a little bit about IP trends in China, and if we could cue the slide, please, I'd appreciate it. I don't know if you'll be able to. I guess it's pretty readable. This is a topic probably covered less frequently in gatherings like this, so I thought I'd touch on the latest developments. But first, I'll tell you a story. About 10 years ago, I was seated next to the then head of China's IP authority, along with each of his patent and trademark leaders at an IP conference luncheon. I don't remember which meeting it was, but I do recall we were looking down Barcelona's beaches. And I thought, it's kind of an odd venue for Chinese government officials. When I asked the purpose of their visit, the CNIPA, which is the China IP authority, minister told me that they were on a mission to glean best practices from European and U.S. IP regulatory bodies, industry groups, and courts in the areas of patenting, licensing, and litigation. They intended for these learnings to inform the evolution of IP governance and practice in China, which was under construction at that time. Much fun is made of the Chinese penchant for copying, but this ignores a genuine cultural underpinning. Lenovo partnered in 2013 with photographer Guillermo Torres to launch a new global marketing campaign with stunning imagery, taglined, "Different is better." The approach garnered many awards and proved highly successful outside of China. When Torres was tapped 5 years later to help revitalize and reinvigorate the campaign, our China leadership protested across the board. They explained that the capability of adopting and adapting the best techniques from others is deemed by Chinese to be the superior approach over striving to be different. So our worldwide marketing pitch celebrated the renegade, but it confused and annoyed customers in our home market. We've replaced it with today's tagline, "Smarter Technology for All," which aligns with both our China and rest of world constituents. Successor officials to my lunch companions are hard at work in China to adopt and adapt the best IP practices from other geographies and regimes. Let me share a little bit more on what they're up to. We'll put up a slide, here's a slide covering additional developments in case you're interested, but I'm going to highlight 5 of the key developments in the past year and a half. So first, there's a very pronounced policy shift in China from patent quantity to patent quality. This aligns with the 14th five-year plan for national IP protection and applications, which was issued by the State Council last year. It clearly resets China's national IP strategy as quality comes first. This represents an intentional shift away from incenting technology companies to file as many patent applications as possible, no matter their potential value. Along with this, the China IP Authority has introduced a series of measures to regulate patent filings for the purpose of improving patent quality, including defining the technology priorities for so-called high-value patents. And by the way, if you read through this in any detail, those priorities are also the priorities the Biden administration is targeting with its limitations on the export of IP to China. Along with this shift of focus to quality, unlike in the US and the EU where antitrust is fading away from FRAND disputes, Chinese anti-monopoly law remains an effective legal weapon against SEP excesses. The State Administration for Market Regulation has recently published draft provisions on prohibiting the abuse of intellectual property rights, refining regulations on SEP licensing. So that goes in hand with building a higher quality portfolio in the China national interest and being prepared to aggressively assert those rights. A second development is entering the battle for jurisdiction over the setting of worldwide SEP royalty rates. For the first time in a written ruling, the Supreme Court of China affirmed the jurisdiction of Chinese courts over SEP royalty rates. Since then, Chinese courts have demonstrated their willingness to adjudicate global royalty setting issues through judicial rulemaking in various precedential cases, and they seem especially interested in picking cases that involve the issuance of anti-suit injunctions. I believe this signals that China will not acquiesce to the ambitions of some European courts to become IP licensing nerve centers, much like Texas did before them. A third development is making available up to quintuple punitive damages for willful patent infringement. I assume the rest, or all of you know enough about that I won't elaborate on it. A fourth development is adopting a new relief model of partial summary judgment. It's called partial summary judgment plus temporary injunction. The way this works is where infringement facts have been ascertained, the court will issue a partial summary judgment ordering cessation of infringement while granting a temporary injunction at the same time. So it's a little bit more efficient than the way the European courts do it. It's meant to promptly halt infringement activities so as to reduce potential damages to a licensor. It was endorsed by the Supreme People's Court in a 2019 guiding case, and it's been adopted in Shenzhen in the IP court there and in Hangzhou in the Intermediate People's Court. Both are deemed precedential. This new technique opens a new jurisdiction for obtaining at least temporary injunctions in IP cases. And again, my interpretation is that China didn't want to be left behind the European courts, who have become centers for litigation because of the injunctions that they issue. I think maybe we have an audience member or two from the clinic, which I learned last night does not refer to Case Western's law clinic, but rather to the Cleveland Clinic. I have zero pharma IP expertise. I won't pretend that I have it, but I will just simply draw your attention to a recent landmark ruling in a patent linkage case in China. It's Chugai Pharmaceutical Company v. Wenzhou Hai-Het Pharmaceutical Company, where the Beijing Intellectual Property Court held that the generic drug involved did not fall within the scope of protection of the plaintiff's patent. So you've been enormously patient with me. I want to leave you with two parting thoughts. One concerns IP. The other is only loosely related, but perhaps interesting to share at a cocktail party. The first, in case you haven't already started thinking about it, is to consider the IP implications of the metaverse. I spoke to a bunch of bankers last week, and I raised this, and they all looked confused, and I thought, wow, if the bankers aren't thinking about how currency transactions will occur in the metaverse, we're all in a lot of trouble. Maybe this is the Bitcoin moment, I don't know. I don't know if metaverse has been mentioned in other sessions today, but this new sphere is sure to open up a whole new range of possibilities and challenges in terms of invention and contact protection or not, that we should try to sort of anticipate and sort through more proactively than we managed to do with the complexities of the Internet of Things. Through that whole era, I felt like I was flat-footed, and we shouldn't put ourselves in that same position with respect to the metaverse. The second little parting thought that I'll share is, as a China watcher, I'm consumed by the question whether President Xi Jinping will take concrete steps in his inevitable third presidential term toward controlling Taiwan. Working on this problem is a daily exercise for me, so I am very, very curious to see what happens. Among so many other impacts, that control could have seismic consequences for global access to important semiconductor technology. I had dinner on Wednesday night with one of, I think three, I was counting, I think it's three Westerners who have served not only in political office, but also on behalf of his or her national interests in both China and Russia for long periods of time. So he understands those three dynamics very, very well. U.S. politics, Russian politics, China politics. I asked him the question around President Xi Jinping's intentions, and he simplified the complexities and the nuances around the question like this. Xi wants an economy, and Xi wants Taiwan, but he can't have both. So, food, or maybe rice grains in the bowl for thought, is just something I'm interested in, and I share with you for your further thought. So thanks for hosting me in Cleveland at this esteemed law school today. And it's been a pleasure. So take good care. And if you have questions, I'm happy to take them.
Open it up for Q&A. So if folks have questions for Laura, I'm sure she would love to answer some of them. One that I had to start was, you talked a lot about some of the issues in intellectual property happening in China. And for many of the students here, we don't spend much time talking about foreign jurisdictions. Mm-hmm. What are some of the key things to know for a student or someone who's just learning about the differences in jurisdictions to understand some of those differences between the U.S. and China?
It's a good question, Krista. I don't know if any of you who are students here have heard of Professor Sidney Picker or Professor Jane Picker. They both taught, Sidney was at Case, Jane was here, but they would interchange from time to time. And Sidney, in particular, is a phenomenal international law expert. That's where my interest was sparked in international law. And I know that he still lectures from time to time. That's what I'm reading or picking up. So if you have the opportunity to hear him, please take advantage of it. So I'll just give an example that sort of paints the picture. China has adopted a national data security law. The U.S., as you know, and Europe have their own. Europe has the GDPR. In the U.S., we began this journey on a state-by-state basis, which makes no sense to me, but there are multiple privacy laws in the U.S. My team struggles daily with whether we can respond to a judicial inquiry, for example, maybe initiated in the U.S., without violating the China National Data Security Law. Similarly, we struggle on the China side, and that team struggles to know what can be shared without them having personal liability in China for violating the law. As we sifted through the Russia-Ukraine conflict, we had 8,000 employees in Russia. We had just opened a new Hungary plant in February when the conflict began. All of the Hungary employees were Ukrainian. They would come to Hungary to work during the week and then go back home on the weekends. So we had internal issues to deal with, but we also had this notion of the U.S. sanctions, China's early, now inconsistent, but early indication that it was supporting the Russian war. Frankly, we were told that we had to comply, by the China government, that we had to comply with U.S. sanctions laws, which we knew, and Lenovo complies with all laws in the jurisdictions we serve, but that we couldn't say it. So we went, if you remember, there was a Yale professor who was posting the list of horribles and listing companies who hadn't withdrawn from Russia. Well, we withdrew in the first weeks. We were one of the first companies to pull out our people, pull out everything, stop all business, shut down our repair depots, everything. But we were top of the list as a bad player because we weren't allowed to confirm to any news outlets that we had done all of this. So those couple of examples tell you that we continue to live in a world of conflicted laws. And in a geopolitically coupled world, that might work. But as we start to decouple, and we're forced to look at different regimes and try in one situation or another to comply with it all, it's becoming nearly impossible. So international law, and particularly private international law, is practiced by corporations. It's a fascinating field. And if you have any interest as a student, I would say get an LLM in it, and then find either a firm that is serving global clients or come into a global company and get a taste. We've intentionally expanded our internship in Raleigh, which is our U.S. headquarters, to steer away from Duke, where we always hired our interns, to North Carolina Central State and other smaller law schools. And we found that these folks come in wide-eyed because they've never, when I'm on a phone call with typically 15 people that are each from a different country with different accents, they had never been exposed to this kind of thing. And they're coming out of our program being hired by IBM and Huawei and a whole bunch of different, well, it's not a good example, but a bunch of global companies that can give them international opportunities. I've had an amazing career practicing in this space, and I would recommend it to anyone. I'm very grateful for the things I've been exposed to.
Does anyone else have a question?
Laura, thanks for this. It was very, very fascinating. So I was curious I agree with sort of Carl in your comment about sometimes settlements or negotiations, maybe it's not quite the gentleman's game we all hope that maybe it used to be and should be. But I'm curious, and you guys have been very successful in your licensing in the past. Do you think that it's better for those discussions to happen with the business folks? Sounds like what you did with Kodak. You were able to have the business folks talk and come to an agreement versus mediations where you've got your trial counsel involved in trying to negotiate. I'm just curious, if you, in your experience, do you think that that's a better approach, a more successful approach? And, you know, our mediations, I mean, they can be helpful, they cannot be helpful. I'm just curious what your thoughts might be on that.
Yeah, it's a great question. I think, again, this goes back to the distinction between the old days and the new days. In the old days, and particularly when you were talking about these really big cases, the gaps were big, as I mentioned. And the only way you were going to close the gaps was through some form of business collaboration. So, for instance, it actually didn't happen, but the thing on the table to close the gap in our negotiations with Motorola back then, it's so weird because my Motorola team, some of the same folks are on it today that came from the other side of the table then, which goes back to relationships. The thing that was on the table was a phone-forward camera. So we were going to build cameras for Moto phones, and they were going to be optimized for image quality, which at that time, it didn't exist. It was ahead of its time, as usually Kodak's inventions were. But we were going to work together with marketing development funds and research and assistance from Moto, and we were going to then have this long supply contract to supply those modules to Moto phones. That couldn't have happened without a parallel business team in place who, you know, understood the P&L, understood what would sell, what wouldn't sell, what would be good for the company, bad for the company, et cetera. So we almost always had to have those business teams in place. Today at Lenovo, well, nobody wants to collaborate first, so we're not in these kinds of collaborative discussions with counterparties. But also, they just want to get to the end game, as I've said, and my business clients are interested in BOM. Tell me what the price is. Tell me what the cost is. I want an IP strategy that helps me forecast what I'm paying in addition to product cost for licensing going forward. So it's a very different climate. And we don't often, we certainly report fully to those business clients, and we never surprise them about, you know, costs that's coming down the road. But they don't engage in terms of business win-win ideas like we used to do in the old days. Does that make sense?
Any other questions for Laura?
Yeah, that's absolutely. And so I started Lenovo 6 years ago, and that was the first problem we tackled. Like, no, we will not file on everything, any piece of garbage you come up with. It's not happening. So we already had this value kind of, my IP colleagues and I had this value discipline. And so we applied a rather strict lens to what was being disclosed. The government's done a few things. So, and some of them are detailed in this slide. They've highlighted the technical fields in which patents have the ability to be deemed high quality. Battery development, AI, VR, AR, et cetera, et cetera. So if you're innovating in other spaces, you're not going to win any high quality patent awards. And those awards in China are extremely important because they determine how much money the government funds your research labs to continue development. And those are big dollars. So you want to position your patents in a way that they're winning awards, strangely. They are directing very, very extensive and detailed guidelines around claims construction. So there are probably, 10 initiatives the government has taken to direct patentees on how best to structure a patent application and how to improve its chances of being granted. So it's a good question. Thank you.
Anyone else?
I'm sorry? I have two pictures that I love to bring to budget discussions of the Huawei patenting team and the Lenovo patenting team. And they have like 120 patent lawyers, and we have 7. But in terms of grant rate, we've exceeded them. So again, it goes back to the quality. Huawei has, I'm sure you know, has announced that since it's not able to derive income from product sales outside of China, given the U.S. government sanctions, it's going to be in licensing in a big way. And Huawei has 60,000 patents, so it's a bit of a threat. We are in friendly discussions. So, actually, another Huawei story. We during one of the cellular standards, this is how weird things can be in China. one of the cellular standards setting activities, Huawei was taking one path and Lenovo was taking another. We deeply disagreed on the technology. And we got a call one day from the chairman of Huawei who asked my boss to please be more supportive. And couldn't we just align with our Huawei colleagues on the standard setting committee? And we listened respectfully, but we continued to press for a different technology solution. This hit social media, this is about 2 years ago, that Lenovo was not being a good China company. It was not supporting the national interests of the government. And really, our stock price plunged. This thing haunted us for months, this rumor, this misperception that we were somehow trying to do Huawei in was the tagline. So anyway, we have notwithstanding all this, we have a very cooperative relationship with Huawei, and I believe ultimately we will cross-license our patents.
All right. Well, thank you so much,
Thank
Laura.
you,
We really
Krista.
appreciate you.
Thanks,
coming.
everybody, for your attention. I appreciate it.
All right, so we have a brief break. We're going to be back for the medical technology panel in about 10 to 15 minutes at 2:15.